All right, so now we're out of the North Carolina executive and we're straight into North Carolina judicial branch. So we're now into state level courts. So this is specific North Carolina. I don't know how other states operate, but I can at least tell you how North Carolina operates insofar as how they run their court system. All right, so first you have the lowest level court, which is district court. And I said lowest level. This is the lowest level that involves elected officials. So this is the lowest level that involves elected officials. So we have 39 judicial districts in this state. That's roughly 1.5 per county. So we're talking about, remember, we got 100 counties in the state and we have 39 judicial districts. So, 2.5 per county. So larger counties like Wake County is its own district by itself. Some people actually argue that district is so large in population it should be split into two. But right now Wake County is its own district. Other counties like Caswell and Person are two. I believe Nash and Wilson are together, and there's several other counties that are bunched up together. The mountain counties over by the mountains, there's several counties like Buncombe and a few others will all be, Buncombe County and all those places, like will be bunched in with Cherokee and a few others, like 3 or 4 counties, so a very large geographic area. And again, it's based on population, so you don't want to have one district catering to 10,000 people when the next district over has one district catering to 100,000 people. You're trying to divvy it out and splay it out based on population, much like representation in Congress, but this is for a judicial purpose. All right. Each district has at least one judge, but larger districts can have more than one, and that can be for geographic or for population reasons. So if you have a very large geographic area that you cover, you're going to want more than one judge, because having that one judge hop back and forth and run all the way around all these various courthouses all over the place can be cumbersome. You also might want to have more than one judge simply because there's a big caseload. You're in a high population area. The jurisdiction, or where they have the legal authority to decide cases for these particular court seats, is for misdemeanor criminal cases, juvenile cases, so under 18, domestic and family law disputes, so that would be things like divorce, alimony, child support, that kind of stuff, and civil cases where the amount in controversy is less than $10,000. Once you exceed that amount, Superior Court takes over and the right to a trial by jury exists. There is no jury for a district court. You can't even request one. The moment you request a jury, what they say is basically you have to wait for us to decide the district court case, then appeal it to Superior Court. So there is no way to see a jury in a district court. That means that the judge sitting on the bench is what is known as the finder of fact, and also the finder of law. They answer all the legal questions like, objection, Your Honor, that's irrelevant. Well, that's a question of law. The judge can decide it. The judge also renders a verdict based on the facts, whether it's guilt or not guilt, liability or non-liability in the civil context. All right, on to superior courts. There are 8 judicial divisions throughout the state. Judges rotate within their division every 6 months. So you will have more than one superior court judge in one of these divisions, and what they do is they almost like ride a circuit around the various counties inside of their superior court area. So I know that the one for Raleigh also is actually from Person County. So there's one judge who's actually in Person County. He lives in Person County, drives to Raleigh during his 6-month period, and they just rotate all around. You want to have a superior court judge when they're at home. They're happier when they're at home. But they will have to ride around all the time and basically go to different places every 6 months. And it can become a bit of a game for both defense attorneys and for prosecutors, because sometimes certain judges are really harsh on people. And if you're like, man, I'm a prosecutor and I really want this judge because he's going to nail this guy and not give him any room to wiggle, you want to wait for that 6 months when your favorite judge comes up. It also happens for the defense. Sometimes you'll get a judge up there who's a very liberal person, is very, very individual rights, very tough on the prosecution. If you're a defense attorney, you want that guy. You want that guy to be your judge. You might try to time your case out to where you're in front of a judge that's more sympathetic to you. All right, jurisdiction: felony criminal cases, civil cases in excess of $10,000, and misdemeanor appeals from district court. So most district court cases, and I believe up until recently, that would include things like seatbelt tickets, could be appealed up to the Superior Court to a jury trial. I know it sounds stupid, but it did used to happen. I think they passed a law basically making that no longer possible. You can no longer appeal a seatbelt violation because there's no chance of jail time. It's not even a point on your license. It's just it's an infraction level crime. But back in the day, yeah, you could appeal that up to a jury. And a friend of mine actually had to run a jury trial based on a seatbelt violation. It was his first ever jury trial, and it was in Superior Court, and he had to sit there and be like, when he did jury selection, or also called voir dire, when he did jury selection, he was like, does everyone know what's going on here? Can you be honest? And they're like, yeah, all right, I'm done. He didn't do any real in-depth check of the jurors because he was like, he almost was like, this is ridiculous. And he got a guilty verdict. But the point is, felony criminal cases, civil cases over $10,000, and misdemeanor appeals from district court are what the superior courts have jurisdiction over. So they handle the big cases. They handle the cases that involve like public officials or major murders or crimes or bank robbery, like big stuff. They also handle the cases that involve large amounts of money, and that amount greater than $10,000 is important because in the pleadings or basically the complaints that are filed, if you have a civil contract case or you have let's say it's a medical malpractice case, by law you are not allowed to mention the amount of money if it's over $10,000. They just say we're requesting a award or relief in the amount excess of $10,000, and that's how we'll say it in the pleadings. It will actually get you in a lot of trouble with the bar, with the court. You might get fined as a lawyer or as an individual plaintiff. You might get fined for putting in extra, putting over. You say $11,000, you can get fined by the court, and they can make you pay money for basically breaking the law and putting down a amount in controversy greater than allowed. Now that it could be $1 million case, but all you're allowed to put in there is an amount in excess of $10,000. And then later on, as the case goes on, we find out how much money is actually at issue. All right, a jury of 12 hears the criminal cases. The jury trials are often waived in civil cases. And that makes a lot of sense because most individuals who are on jury duty, they're your average Joes. They're not like doctors, they're not lawyers, they're not judges, they're not even necessarily well educated. They're just your average citizen in the area. And they use the voter rolls to pick them out. Now, the reason why they're often waived in civil cases is that those 12 guys can kind of figure out criminal stuff. They're like, I know what stealing is, I know what bribery is, I know what murder is. They can handle that stuff. But when you're talking these civil cases, they could be heavy-duty contract cases involving, one that's terrible is power companies. Really, really detailed, cumbersome mathematical formulations about, well, how do we run the water company? Well, is there a contract here? Is there not a contract here? And your average person doesn't understand that, but your judge is also a lawyer. He understands those things. And I've seen and heard about this happening in other cases where you'll have an issue where the jury just is not up to the task of understanding what the case at issue is. They're just, the education level is not there, the experience level is not there, the interest isn't there. No one wants to sit down and talk about contract law when what they do is maybe they're a gym teacher or they're somebody or they are a stay-at-home mom. They don't know anything about it, so it becomes a lawyer's job in those situations to become a teacher all of a sudden, and now they have to educate and then convince the person that they're right, as opposed to just going from a judge, which is, okay, Your Honor, you're a lawyer, you know what contracts are, we're going to talk about the main issues, and we're going to speak the way lawyers do, and we're going to get this case done. And usually they settle out anyway. But the idea is that a lot of the time civil cases are just too complex for your average person, so they get waived into basically what's called a bench trial, which means the judge sits there as a trier of fact and comes up with a verdict. All right, on to the Court of Appeals. 15 judges in North Carolina, and they sit in panels of 3, and that's to avoid a tie. They hear all appeals from Superior Court, District Court. The only one they don't hear is death penalty cases. Those go straight to the North Carolina Supreme Court because why bother stopping in the middle? The guy's going to die. He's got no reason not to appeal the Supreme Court, and they're going to hear it. They have what's called an appeal as of right to the Supreme Court in all death penalty cases. If you've been convicted and sentenced to death, you get an automatic appeal right up to the top. They hear cases and appeals from agencies such as the Utilities Commission. That would be your people who handle whether it's it can be power, water, all that stuff. The North Carolina State Bar Association gets appeals from them. So if you're a lawyer and you do something bad and the state bar censures or disbars you, which means they take your law license away, you can appeal that to the Court of Appeals, and then it can eventually go on to the Supreme Court in some cases. All right, then we get to the Supreme Court. The Chief Justice and their 6 Associate Justices. So we have 7 total people, where at the U.S. federal level it's 9. They hear constitutional questions. That can be constitutional questions in the context of the federal constitution, like the Bill of Rights and all those fancy things. It could also be the state constitution. There are certain provisions in our state constitution that are radically different from the federal constitution. For example, in North Carolina, we have a constitutional right for our kids to have a sound basic education, and that's been interpreted to mean education from K all the way through 12, to have it provided for you at state expense. So that is something special. There's no education requirement at the federal level. It's only in North Carolina and a few other states that have that requirement. They also hear appeals from death penalty cases and all appeals from the Court of Appeals. So again, much like in the federal system, you have an appeal as of right to the Court of Appeals. As long as you pay the money, they're going to listen to your case. That's why there's 15 of those kind of justices as opposed to 7 here. And just like at the federal level, the Supreme Court of North Carolina can choose whether or not they want to hear a case. They don't have to hear it. Just because you appealed it from the Court of Appeals doesn't mean they're going to listen to it. And I think one year they only took like 100 cases, so their numbers are pretty small. They only consider errors in legal procedures or in judicial interpretation of the law, or as we call it, questions of law. So that's the issue. We're talking about due process rights. That would be the legal procedures portion, or misinterpretation of law or questions of law. That's what they deal with. They don't deal with facts. They don't decide how many pounds of cocaine there were in the car. They decide, was the cocaine seized legally? All right, on to electing judges. So this is different. At the federal level, we don't elect judges. They're appointed by the executive and they're confirmed by the Senate. In North Carolina and many other states, judges are elected by the people. Now, they are supposed to apply the law in an impartial manner, regardless of their own personal views. And the reason why we have lifetime appointment at the federal level is because we believe as a country, or at least our founding fathers believed, that if you appoint a justice for life, then they're never going to do anything that violates the Constitution to try to keep their job. They don't have to worry about it. They're not going to be like, well, the citizens, they really don't like this guy, but he got messed up by the cops. The cops totally messed this whole case up, and now we can't do it, and now he should be let go. We need to let him go because the state violated the law when they tried to arrest him and take his stuff, and that was illegal, and technically we're supposed to let him go. But man, the people get so mad at us and throw us out of office. So now we're going to find him guilty no matter anyway, even though he shouldn't be. That's what they were trying to avoid, that kind of situation. They thought that, well, if judges don't have to worry about losing their job, they'll have impartial decisions that aren't based on keeping their employment. Their decisions are not supposed to represent a particular group or favor any political party, although we do have judges that basically run on the Republican and Democrat sides. And I believe our elections currently in this state are called nonpartisan elections, meaning when you see the ballot, it won't say Republican or R or D next to their name. It'll just have the name of the judge. But they're trying to actually switch that around. They're trying to change that so you can tell if a judge Republican are running on a Republican ticket or a Democrat running on a Democratic ticket. Now, here's the pros of electing a judge. And there's only really one. You get to remove incompetent judges more easily. So if a judge does some weird stuff like, I'm going to get rid of all these DUI cases now by just dismissing them, well, now you got a bunch of drunks on the road again, and that might be an issue. So all of a sudden, they look incompetent. Now, if a federal judge did that, it'd be really hard to get them removed. It would take impeachment. If a local judge at the North Carolina level does it, all you got to do is wait till the next election and throw them out of office by electing somebody different. Here's the con. Elections will pressure judges into supporting popular causes simply to get elected. There was a very, I think it was Paul Newby running for Supreme Court justice, and one of the things like, justice tough but fair, like he was tough on crime and all that stuff. And the thing is, when you're a judge, it's not about being tough on crime. It's about being impartial and following the law. So these commercials are coming out that were very like, okay, this guy's clearly conservative, clearly anti-crime, so he's going to be very anti-defendant when he walks in the door, and that's what you want to avoid. You want to avoid that preconceived notion of, okay, this judge is going to go one way or the other. You want someone there who's impartial, who's objective, and that's the biggest con. Well, maybe he's trying to get elected, so maybe he's going to be something really tough on people and just decide that they're going to be he's going to lock them up, throw away the key kind of stuff, or I'm going to impose harsher sentences than are justified because I want to get reelected and I don't want to seem weak on crime. All right. District court judges, they're elected for 4-year terms, so that's a good thing, nice and short, but it's still an awful long time for someone that has a pretty large amount of power when you're talking about the court system. Superior Court judges, 8 years. They serve longer than senators. You can have again, there's no term limits on these guys either. That's the other thing. There's no term limits. So they can just stay in there for decades at a time, and they do. Court of Appeals, they're also elected 8-year terms, but they are voted on statewide. So in the district courts, you're voting for a judge in the district. That district population, which is fairly small, are the only voters. Superior Court, they're a very large geographic area. Remember, there's only 8, so they're talking about a much larger geographic area of voters. And Court of Appeals is a statewide election, and so are the Supreme Court justices. Everything above Superior Court is 8 years. Everything above a Court of Appeal, everything on this is going to be everything below. Everything below Court of Appeals, 8-year terms, elected by the statewide voters. All right, here's some other different judicial officers. Now, some of these, and I'll point them out, are not members of the judicial branch. We just call them judicial officers because they're always in the courthouse, and that's where they work, and that's where they do their business. All right, all North Carolina courts are organized by the state. Here are some other weird local officials, and these guys aren't always elected. Magistrates, they issue warrants, hold pretrial hearings, and decide on bail. They're not elected, they're appointed. And they also can deal with small claims courts. They don't have to be attorneys. They don't have to have ever been a judge. They could have never even actually been involved in a legal case or even been a paralegal. Magistrates don't really have a legal background. And because of that, any decision they make can be appealed to a court. Like they are never the final decision, even in small claims. Small claims, if you don't like the decision, it gets thrown out. Like small claims looks a lot like Judge Judy. That's what that looks a lot. Those hearings, that's what they look like. Then you got the district attorney. He's elected by the voters, and he represents the states in criminal matters. Or as we say, he's the prosecutor. The district attorney or the head prosecutor, or any prosecutor for that matter, is not a member of the judicial branch. He is a member of the executive branch. The police arrest them. The DA will prosecute. It's all enforcing law. So even though this is under this whole judicial officers section, they are not a member of the judicial branch. Their job is to enforce law, in particular trying to convict people for breaking laws they believe have been violated. And then you have the public defender. Again, not a member of the judicial branch and not actually a member of the executive branch technically, although they're technically paid out of state funds. They represent defendants who are unable to pay for their own attorney, so we call those clients indigent, people who can't pay for their attorney. You hear that famous Miranda rights. If you cannot afford an attorney, one will be appointed to you. That's that portion. Public defenders represent people who literally don't have the funds to represent themselves or to pay for representation. All right, guys, and that is the end of this presentation, and I'll probably have an assignment for you when you're done, so come talk to me, and I'll get you set up.